It's very important to understand what are all the new changes, what are all the timelines which are available, what is meant by the new. We have already seen in our last webinar about what are all the key requirements from remittance industry and digital currency service providers, other fintech entities. However, there is still a very huge amount of confusion. And on top of it, by February end, the Australian Information Commissioner issued a new guidance requiring AMLs, reporting entities to comply with most of the honest requirements of the information security and privacy principles. So we will be just going through all those requirements and what is relevant to the reporting entities who have attended this webinar today. And there is a very heavy load of slides today. I have stacked close to 45 of them. And what is important is please pay attention and just pick up those relevant items and make a note of it. I am actually coming around meeting people in Sydney and Melbourne, and I want you to take those questions. If we have time left in the end of this session, we will look into those questions. Otherwise, you can call me or meet me in person, and I'm more than glad to help and see how much, because I am an auditor, I have my own independence, but at the same time, it becomes my duty to clarify what is required so that you can be prepared for external reviews as well as any spot audits ASTRAC can make, because they have acquired new rights, new powers to pay an unannounced visit to anyone and record conversations or seek documents or take away recorded video clips or audio clips, etc. So therefore, it is very important that we understand the pressure of regulators now and see the gaps, what is really missing in our environment, and then try to see what best can be done in the near future. Because for certain compliance items, there are time until 2029, but it comes with a caveat. You should have been a registered reporting entity or a designated provider as of 30th March 2029 or before. And then you must have an implementation plan, very realistic and practical. And also, if you are delaying certain things to very long time, you need to have justifiable reasons as to why that is delayed until 2029. Not all the obligations are can be delayed, so please pay attention to it. While we speak about it, please take inventory of where you that today. And what is more important at this stage is whether we are doing mistake or not, but what is gap. From the conversations I had with the meetings I had in Sydney in the past 1 week, I have understood, people have even problem coming out of their earlier mindset and try to even understand, if they don't come out from the traditional mindset of it's okay. There are so many things which are, I'm not intimidating. Please don't take me wrong. There is a new generation of regulator employees who won't be understanding where the remittance providers are coming from in terms of debanking, in terms of the outreach, the new learnings and the shortcomings of the industry. Everything has gone. Now you will be seen according to the papers and assessed. So please try to understand. And the most important thing for our members, because as we know each other, you need to get out of that mentality that it is okay for me and then understand the requirements and then take an inventory of what is missing and how we are going to work. There are many alternatives. There are cheaper alternatives. There are, very, very high level, enterprise level alternatives, but we can sit down and think and look at those alternatives. But the most important thing is to understand what is missing and where our mentality needs to change. I'm stressing to that word, and I'm giving more emphasis to that word, because please, assuming that I'm small is not an alternative to this, the whole focus we are looking at. So there is a huge change which we will be seeing in the coming slides about what was our ICP, the identity verification, identification, customer identification program, and the current initial and ongoing customer due diligence program. The industries we are going to be now looking into is digital wallets, remittance providers, and small fintechs. The timeline we are talking about from beginning to, make a complete, um, uh, fully compliant compliance framework is 2025 to 2029, because there had been so many requests from reporting entities to Home Minister. They have gone in and tried to facilitate this whole implementation of AML/CTF Amendments Act 2024. To make it easy, the transitional arrangements are really going to be helpful. I have 3 surveys, poll surveys, to make a little assessment of how our members are in their compliance implementation plan. So please answer those polls as we come to those in a very honest way, so we can understand and try to make more elaborate arrangements to make more clarity for misunderstandings. Our objective today is to understand transitional AML/CTF reforms, which is 2020-46, but it goes up to 2029. It is as of now, but the arrangement is up to 2029. And we are also going to look into the Australian Information Commissioner's expectations on the ID handling, align these practices with Australian privacy requirements, implement practical controls for compliance teams. In looking into those, the reference of how many regulations is the AML and CTF Act as amended in December 2024, and then the ASTRAC rules, which issued by the CEO of ASTRAC on 28th August 2025. And then please note, Privacy Act did not change from 2000. 10 or 11, the Privacy Commissioner, the Australian Information Commissioner, has really coordinated with the Department of Attorney General, and they have emphasized through their guidance what needs to be superseding when complying with AML/CTF Act. Previously, what we could live with were the privacy principles. There are 13 principles which say no, 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 no to certain items. But if your customers were consenting that you could be taking these information, and for example, the privacy principle says Australian private information should not be passed on to overseas entities. That's one principle. But if you have a privacy response by saying that if your customer consents to the fact that they allow you to do, without which that completion of that transaction is not possible, you may do so. This had been the case so far, but it is fast and shockingly changing immediately. So we'll be looking into what it will end up someday, and then we will also look into the commissioner's guidance, which was issued in 2026 February. So the customer identification procedures or program CIP is about to be absolved. On that place that they are introducing initial and ongoing customer due diligence. There are key differences because this CIP actually had a safe harbor protection. If you have done collected ID, verified ID, sanctioning, PEP screening, adverse media, you could have basically said that I have done what reasonably could be done. But now, with a small exception, they have removed safe harbor provisions, but however, they have put the onus on the reporting entity to make sure that they collect, verify, and risk score each customer based on their classes of sections, however you have divided, and also based on the designated services you have provided to them. In our case, this designated service is either currency exchange or remittance provision or virtual asset service provision. Therefore, the risk scoring need to be mitigated, and mitigation as such is eliminating the inherited risk with mitigation process and keep a very close watch and control over the residual risk left even after doing the ongoing the customer identification process, etc. So this need to be dynamic. So in my meetings, I'm telling people to have a risk scoring based on what they consider can be their customers' overall risk um, at the time of onboarding, like age, income capacity, place of birth, and the destinations connected, the number of accounts they hold, the number of beneficiaries they hold, etc. Those may bring you the overall risk faced by the customer at the time of onboarding. But however, if you are building a system, you need to keep space for dynamic risks like what they have told you and how their behavior along the transaction monitoring program looks like. So in your initial customer risk scoring, if you are allowing 80% of scoring for inherited factors, and then you may hold, I'm just giving you an example from what I can tell you, give 20% uh, score to dynamic risk, which can surface from their transaction typology, the jurisdictions they deviate from what they have disclosed to you, and the investigative outcomes which brings those results. Therefore, by doing so, if you hold a risk scoring module within your system automated, you create a pivotal approach of dynamic risk from linking transaction monitoring program and the ECDD procedure, then you can actually allow them to operate according to individualized risk bracket, risk boundaries. At the same time, you can also satisfy the regulatory requirement of having ongoing customer due diligence. Yeah, by saying customer due diligence, we are talking about identification, verification of the identification, the recommendation. If you are trying to balance with the information commissioner's recommendations, the verification, they are recommending any service provided through government portal like Commonwealth portal or recommended than buying third party, or if you are buying from third party, please make sure that their source of data, this source of truth is actually Commonwealth portal. So ongoing monitoring is looking for those residual risk which is coming even after the ongoing customer due diligence. So why it is bringing, why when we speak about risk based approach, this is a bit of a relaxing thing to think about. You imagine that there are banks which are doing so much of ongoing due diligence. Whereas if you justify that the risk you are operating within is very low risk, but don't just assume that all your customers are low risk because you know them through your community center. But on a more scientific approach, if you think that, if you can justify, not just think, if you can justify that your customers are posing very low risk in terms of the value, the the potential to cause any predicate offense, then you may be really justifying that your customers are a low risk, and therefore you can reduce the amount of checks and balances you do in with it with that proportion. So you have, in that risk-based approach, you have an independence. But remember, the regulation has moved from tick box to harm reduction. So even if you classify that the risks are low risk, it's not high. It's your judgment call. But when a regulatory assessment reviewer comes and says, "Hey, this is not low risk," from from the industry benchmark, they can actually ask you to modify that risk and take it to either moderate or high. Therefore, in the beginning, yes, you can take your judgment call and make as much justification for your judgment, and you can devise your mitigation processes based on the level of risk you are taking. So this is an independence. By just removing that safe harbor requirement, you can actually go low and do less for real low risk things. Even when you have to do a re-KYC on a, let's assume that your compliance program at, at one stage is calling for mandatory sanction screening and PEP screening every 3 months time, and then you say, "Hey, we don't need to do for our low risk customers. We can actually do those in 6 months time." I'm not suggesting to do that, but those are the privileges you can take according to risk based approach, as long as third party. That's why the regulation and the legislation is emphasizing on external review, so that your certification is endorsed by a third party that what you call as low risk is actually low risk. We just spoke about that. So I am a very strong advocate of making your program active. I think in the last 5 years, we have been talking about a dynamic compliance program where it actually synchronizes with your software, your conduct in the business. They go hand in gloves with, and they also update each other so that they remain more current, meaningful, and practically helpful to you and your employees. And also, it provides very true reflection of what is happening within your organization. Therefore, please make your compliance program more detailed. As to, let's take, this is something which is not in this slide, but let me take this through. I have spoken to people to have 4 sections, 4 contributors to your compliance program. First and foremost, your pillars of compliance program. Those are like, which we have listed in the earlier chapter 6, which goes from registration to your governance, your ready preparedness to receive and respond to abstract clarifications, appointment of AML appointment of external reviewers and internal reviewers, employee due diligence, employee training program, UBO, sanctions, transaction monitoring, PEP screening, ultimate business owners, enhanced due diligence, customer ongoing as customer diligence. These are all things which comes under the pillars of compliance program. Take these each pillar and go what is required of you, the requirement, and then what is your response, but make it in detail. Don't just say we must appoint a external auditor and he must come in every two. Please make it as much detail. Who is your auditor? How do you recruit them? Who can change them? What are their scope? How frequently do you do? What happens after their review? How do you take the review through mitigation process? AML Co must take this to the board and brief them at least once in a year. Go like so much detail that if a new person walks into your company and tries to sit in one of the seats, he must understand or she must understand what the previous person had been doing, that much detail, so that someone can turn the page and learn the work. That kind of detail is what is necessary for your compliance program. And then the next point you must incorporate into each pillar is the requirement, the response, and then the alternative. So if your response is straightforward, they fail, what is there to come as plan B? Plan B. Therefore, you need to approach each pillar of compliance under Chapter 6 with requirement, response, detailed step by step details, and then what is your alternative if any of the steps fail. So you are completely on it. You foolproof all your failures. And then remember always these requirement, response, and alternative, these three steps and the steps within your, remember that as a template and apply it to all the risks you have assessed in your risk assessment. And then the third area is go through your annual compliance report. Your annual compliance report is going to show you a lot of what you are, read through the questionnaire in full and read through the options given by your regulator ASTRAC at the time you have your choices in against each question, and look at those things like when do you change your compliance program, when do you you review and revise your risk assessment, new risk, regular scheduled review. Take all those. If you have not ticked those, see what they mean for you from a regulator's perspective. That is exactly the annual compliance report is a key document which the ASHA can form an opinion about you based on your responses. So take that and try to fix as many choices for you within the compliance program. And then finally make it more dynamic. You also incorporate your transaction monitoring rules and then look at those, how what kind of weightages, because in your compliance annual review, the transaction monitoring rules, they are expecting you to update all the time. They are coming over many of our reporting entities for even small shortcomings on transaction monitoring rules. But to be honest, most of us are not even doing transaction monitoring. What we think transaction monitoring is that I come across something and I report it. That is not anymore the approach. That is actually a 10-year phased out approach. You need to have rules, and those rules need to be, or at least at a minimum. What is minimum? There is nothing called manual transaction monitoring. At least you should have an Excel based macro rules which can flag your deviation from transaction patterns and give you the opportunity, list you the tickets for you to commence your investigation. Therefore, please, 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 again, I emphasize, come out of that mentality. I am adequate, small. I do transaction monitoring, and where we don't even understand what is transaction monitoring, we don't even understand the difference between what is CC, is customer ongoing customer due diligence, and what is enhanced due diligence. Okay, if you are dealing with corporates, you also have to look into change in ownership. Obviously, suspicious transactions are the result of transaction monitoring, as well as what is physically and on a daily basis, what we see as a difference at our own naked eyes. Change in customer behavior. Again, we need to have appropriate. If you are using a software provided by a vendor, ask them to send you what are all the red flags they are now currently having. And if your compliance program is asking for more, if obviously in my next review, I'll be definitely looking into the transaction monitoring shortcomings, the red flag inadequacies. If your reviewer says that you must have this many, and if you don't, you better approach your software vendor, and you need to have a. We will be talking about the reliance risk and documenting their responsibility, uh, um, data security, etc. We will be seeing those in the next coming slides. So please be vigilant of what triggers can cause those due diligences. Okay, the transitional arrangements are to most of our reporting entities, they are actually very generous. You don't need this much stuff unless you are developing your own. But please don't, if you don't have budget, if you don't have plans, don't just say I have plans to update, because they want to look at your serious plans, practical budgets, resource allocations, etc. So if you really can do something, do it. I personally don't suggest you to make use of these transitional arrangements. Don't go beyond May and June 2026. It's a good idea. The one thing which we all have little comfort about is the continuation of IFT. They are not replacing it with the travel rule. The travel rule is postponed until 2029 June. Therefore, that is one common seasonal arrangement which we all will be benefiting. We'll be still looking at regulatory solutions without causing additional debanking, and also the timeline for us to build the infrastructure. So when we talk about transitional period, it starts from 31st March 2026 and ends on 31st March 2029. They say the old CIP, the Customer Identification Program, can continue for limited time if you were a reporting entity on or before 30th March 2026. See, it has a time that 30th March, because from 30th March, the new law came to effect, the new rule came to effect. Therefore, if you were a reporting entity and a designated service provider on or before 30th March, you can avail this. And this CIP privilege is not available for any new applicants to this registration for any of the reporting entity or designated services. So you should have a transitional plan, and this must be very realistic. You need to be able to substantiate your resources and your timeline and your seriousness to any regulatory inquiry. Then that plan should have a phase out plan when you are planning to phase out the simple CIP and getting into the initial and ongoing customer due diligence program. So you need to, if you have a multiple classes of customers, if you have plans to pay out class 1 by August 2000, and then by February 2027, class 2, etc., you need to have a very clear plan and what your development plans, etc. So international value transfer services, they have time up to 30,029. the wallets also, they have time until 31st March 2029. When it comes to WASP, virtual asset service providers, which are currently known as, they used to be known as DCE, digital currency exchanges. Um, Whoever were registered digital currency exchange as of 30th March 2026, upon your re-updating of your business profile, you will be moved to a public register, which is known as Australia's virtual asset service providers. So you are automatically gone into the WASP register from DCE register. I will also emphasize why you need to update your fast track business profile on or before 30th May. Don't delay this process, please. When you do that, you also mention that you are a member of Australian Remittance and Currency Service Providers Association, because this is very important for our association to have prominence and continue to thrive to service you. If you are not a member, it's not a very costly affair now. Can you please approach Munir and renew or become a member? Because as a united front, we all will be really benefiting from this. So it's a very important time that in that now they are asking whether you are a part of any industry body or representative organization. Please mention it is Australian Remittance and Currency Providers Association. If you have any doubt, you can call me. While updating, what is happening is they are actually taking it to an enhanced database where the old data will be refreshed and stored in a different place, in my opinion, maybe for better governance. Therefore, when you renew, you must renew, sorry, not renew, Astrac business profile on or before 30th May. And in doing so, there are new questions inserted, and it also includes your director's identification number. If you don't have one, go get it through um, Australian My ID. It's a federal government initiative. If you go there, you can browse for director's identification number. If you have a strong My ID portal, you will be able to generate one quickly. Otherwise, you need to upload more documents to obtain one. That's currently optional. You need to have a director's ID. Also, there are questions about your income, your turnover, etc., and also your workforce, how many employees you have, etc. Those are to determine whether you are a small business or not, but be honest in those answers. But again, reiterate, don't forget to mention Australian Remittance and Currency Providers Association as your membership body. In the transitional arrangement, if you are a company which have registered permanent establishments across other jurisdictions where those jurisdictional laws are forbidding you to comply with Australian or contradicting with Australian requirements, you need to update ASTRAC by 30th 2026. In other words, let us say you have a permanent establishment in London, United Kingdom, and the requirements in United Kingdom has separate requirements which makes your compliance with ASTRAC rules hard. Be mindful here. Okay, let us say if both can be managed at a time in a parallel, we have an excuse, but one is really contradicting another, and you have a problem in complying with Australian requirement, you may approach ASTRAC by 30th June 2026. Beyond that day, you will not have an excuse to let that happen. So the safe harbor, as we mentioned, is also valid for for short period of time for those who are transitioning in good faith, and this is subject to you having an implementation plan. As a transitional timeline, this is more not a legislation or a regulation. This is my suggestion. This is exactly something which you can practically take. In the phase one, which is already over, you need to be aware of what is the requirements and then get a third party to assess what is your gap rather than just you with the same old school mentality looking at it. It's a good idea. They can find more and be transparent. Therefore, you get someone to look into. I'll be more than glad to help you with that gap assessment and then redesign your policies. When it comes to policy, not just AML CTF, it is the risk assessment, the mitigation processes, the sanction policy, the employee due diligence policy, the employee training schedules, training materials, and then your privacy policy, data security policy, etc., which we will be seeing in detail in the coming slides. I don't think we'll be able to finish within 1 hour. And then look at your system, whether it is your own or don't just depend on legacy systems. If you have to really abandon something really, really cheap and old and traditionally struggling to keep up with the new requirements, do something to, where we have this problem, we are a small organization, we can't do much. Phase four should be your full compliance enforcement and be ready to to receive an external reviewer or even someone to walk into your organization from Austrac side. What you can still use is existing customer identification procedures temporarily until more clarification from Austrac is coming, because we have sorted some clarity from Austrac during a meeting. They were not ready yet. They may have to go back to Information Commissioner and receive some sort of coordinated guidance instead of, temporarily we can still continue. If you can use those current onboarding systems, if they are already compliant, because for most people, these changes are not really new. I know many people who had these risk assessment from 2015. Existing customer identification process are okay, and then they can store ID documents if they are lawfully obtained. You know what it means? Lawfully obtained is, you have a terms and conditions which are signed by or acknowledged by your customers through e-signatures, through your app or website. Even they log in, if you have terms and conditions listed there and they ticked and agreed that they accept these, and then they allow you to hold and use this for legitimate purposes, you can still store those if they are lawfully obtained. If you don't have a terms and conditions which authorizes you to collect and hold, please go back immediately, verify and update your terms and conditions and your privacy responses to all the 13 Australian privacy principles immediately. You don't have any excuse for not having an Australian privacy principle responses. You may have to reformulate your Australian privacy and Australian information security principles once we receive more clear and clarity instructions from both ASTRAC as well as Information Commissioner. These are all things potentially very harmful. You may be doing unlawful collection and retention of Australian ID documents. Therefore, it's very important. Go back. This is urgent to go back and review your terms and conditions and your Australian privacy principle responses um, and your Australian information security. What you must start changing is just come out of your old mindset that everything is fine. I have taken photocopies and filed in a box file and left it in my shelf. It's not anymore an acceptable way of handling Australian privacy principles. You must devise, whether you are handling ID documents through paper form or electronic form, you need to devise has access to, how secure you hold them. You must not allow everyone to view them. You need to really classify your workforce as to, let's say, if someone comes to your office and if they just take any file and they can access those information, it is not okay situation. Please go back and see you have received these in a very challenging environment. You have to secure it as if it is gold. To start with, it may be increasing. These responsibilities may be increasing, and we will be talking about what are the best practices, notwithstanding whether you can do that or not. But having collecting them and then putting them in bunches of papers which are not protected, which are not secured, is not an acceptable way of handling customer documents. So they also see, okay, look at your obligations and be precise what need to be collected. And the approach must also shift from collecting hard copies or hard images of documentation than a narration, a file note of what you have witnessed, and you may be able to also destroy those, whatever you can destroy without having to retain. This is an evolutionary thing. We are going to continue monitor and update, and we will be developing systems together. But non-action is not an option now. So the commissioner's core principles are: only collect what is required, match risk level, protect identity data. You may, after entering into your system, you may be able to mask or conceal those data if you are keeping them available to everyone. And even in the systems, you need to see who has access here, who has access overseas, and how you can protect it. We always know our developers have access to everything, but if you're if you don't develop ways to audit who they can subcontract, where they can store your data, how vulnerable your customer data is in their hands, I think we need to try document and make formal agreements with them that I have an audit right over you. You also need to update me your data vulnerability check reports. Also give me all those cybersecurity reports, etc. If you have an agreement with your vendor, and if your vendor agreements are not having these clauses, you definitely have to go back and fix them immediately. So identify the Australian Information Commissioner is so fussy about it. So the Australian identity theft is in the rise. Data breaches are concentrated. Data breaches and hackings are happening everywhere. Sometimes back in the last 2 years, one of our own members' site uh, got hacked, and that was a very big alert that the hackers are not just looking at big companies' vulnerabilities. They are also, because the big companies are building more secured systems around, they are spending millions of dollars in securing their data. So the thieves they are ready to accept even $20,000 benefit by hacking any of the small companies. So that is a very good reminder that smaller companies are definitely not their target. So in the last couple of years, smaller companies are becoming hackers and the thieves target. Therefore, please find what we can do, what you can ask your software vendor, or if you have a dedicated data warehouse or data secured cloud, please make sure that you review or get someone who has the professional knowledge and skills to do that. So these are passport numbers, driver's license. You remember last couple of years ago, Optus got hit by a major data hack, leak, data stealing. They went ahead and paid for credit check for all their customers. Some of the state driver's license issuing authorities have introduced card numbers against driver's license number as a supplementary identification, so that when a card detail is compromised, you can reissue a driver's license with the same driver's license number, but with a different card number. So when you put that to borrow or do some wrong things, if the card number doesn't match with the driver's license, the check will not go through. So those are all new defenses which authorities and the companies which were hit by um, earlier data thefts have caused. Mm, Sensitive data need to be protected. At the end of the day, if there is a data breach, you are responsible and you need to let the Australian Information Commissioner know about it. So collect only when it is required, and collect only those documents which are proportionate to your risk. Don't just ask for everything and anything and put that in your folder. And you can also duplicate the storage if it is electronic. So what is the difference between verification and retention? Verification is the process of confirming identity and authenticity. And retention is storing evidence, and this is for practical reasons to do your own internal process work in synchronization with one another, in tandem with another. Also, you need to prove to auditors and processes that you are retaining. That is exactly where all these challenges arise. It's easy to people will be very, very happy to not to collect ID and collect and then shred immediately. But the integrity of the whole system is in danger once if that is to happen. Otherwise, there is a lot of things to happen, including publishing all your systemic processes and data collection and retention in technology like costly blockchain technology. So where it is heading up to? So if you are a very big enterprise who can afford, you will be tokenizing all these instead of storing in full ID numbers, either encrypting and decrypting or identifying and de-identifying. Those are all alternatives available based on how much budget you have. Masking sensitive fields is another alternative, but then when it comes to verification and re-verification, then there may be an issue. So I'm not suggesting that you should ignore Australian Information Commissioner's guidance. We must uphold it as much as practicable. And also, as a community, we will be seeking more clarification and try to build um, our strength as a community. So, privacy principles, privacy law was enacted in 1980. It it came through a very huge amount of amendment around 2014. I remember. I don't remember the year. It was national privacy principle. It has become Australian privacy principle, and it has 13 principles. Every reporting entity must have a privacy response to all the 13 principles. And the one thing which you should remember is customers have the right to review the data you hold. They may ask you to update some of the fields, some of the data components that these are old. I have a new ID, I have a new address, etc. They may also ask you to delete. That is one area. When they ask you to delete, you can delete and stop having them as your customer. At the same time, you have a record keeping obligation to AML CTF Act that is for 7 years. I definitely have some practical examples of one of our member, the voting entity, went to Westpac and asked them, why do you keep, we stopped holding account, other you debanked us in 2014. It has been over definitely 12 years and you are still holding our data. They came back and said they, under AML CTF Act, they have the right to hold those information. We actually did this with a view to offend them for their debanking act of debanking, but they came back with this. But I don't know whether the information commissioner will support such stand of banks even today after this guidance. That's only a question. I'm not saying anything. So the data minimization practice we spoke about, see the access and storage. The access control must be limited because we spoke about who has the limit, what kind of information is available to frontline staff, what kind of information is available to AML team. So we need to devise those access privileges and make sure that the information and also make who there are institutions where they can see who is downloading what from the overall database. Even those who have access, whether they are acting with integrity, those are all things you need to really have logs and control of. Um, Sumit? Okay. I had some surveys which I thought I should be asking. So only retain those data which is necessary to be kept for 7 years, and then consider de-identifying those documents. For destruction also, these are practices we must have already practiced. But if not already practicing, please go back to these practices of destructing, how you destroy, how safe you have done all those. There are commercial companies who can come to you and destroy those papers into small fragments in front of you. And these are all consideration for big enterprises. Use of trusted digital ID frameworks, avoid storing raw documents, leverage of government verification services. If you are outsourcing means also having a software which you are subscribing from outsider as vendors. I ensure that your data is protected and you have clauses to protect those. And it's a good idea to all actually take periodical backups and keep in your custody. If you are considering data warehouse or data storage cloud. Make sure that they are of Australian data residency in order to reduce. Even sometimes governments intrude into enterprise data to have information relating to their national benefit. Therefore, it's a good idea to have an Australian data residency. And you must ask for audit rights. You can send an auditor and make sure that they do the right thing. Look at data leaks, inside misuse, system vulnerabilities, notify under notify data breaches to the Australian Information Commissioner. And you must also notify affected individuals and should have a budget to compensate if they are in direct loss because of your breach. As a governance expectation, this should have been in the earlier part of this presentation. You should have a board oversight. The AML CTF program updates need to be endorsed by the board, and the compliance issues need to be taken to board Malco, and they also must know the privacy integration and any possibility of risk of breaches and the impact that can bring to the overall enterprise. We spoke about AML Co, their qualification, experience, and fit and proper. Once they assume their role, and their name must be updated on or after 31st March 2026. After they take over as an AML Co, they need to ensure that they are in compliance with the AML CTF obligations, privacy requirements, and then oversee the ID handling and record keeping controls. It is their responsibility. So you need to update your CDD policy, compliance program, risk assessment documents, privacy policy, data retention policy, information security. And also you need to have a IT policy of how your frontline employees are using your computer while at work for personal purpose. If they are checking mails by mistake, if they open any links that are leading to data breaches, that's a very dangerous situation. You must devise internal IT usage policy as to how they store their password, what is their equitable usage of company resources, including devices and computers, what they are allowed and what they are not allowed in the interest of data breaches and information leakages, whether they can bring devices and upload things from your computer to theirs and theirs to yours. These are all things need to be documented, and when they are onboarded, these documents need to be signed, and this is also need to be a part of frequent employee training. So these are all the control checklist: data minimization, encryption, access control, monitoring, audit logs. You need to make sure that you are preparing for internal, external audit and regulator visits to you. The regulator is expecting you to provide evidence-based compliance, documented decisions. Please document what you are thinking in your mind whenever you make some decision. This is one big shortcoming I'm seeing from time again, that people think something, they are doing right thing, they just think and they just speak and go. Please, whatever you are thinking, make note of all your decisions. Whatever you spoke to customers, document them. Whatever responses you have received from customer, document them. And go through, don't just keep a diary, go through a patternized, templateized, systematic approach in documenting your decisions. Make risk-based justifications and document your justifications, why you came to that decision. Willful blindness, but you need to really pass that test of how an 18 plus adult would be making that decision. That's the test in the court. Gap analysis. This is the recap of what we have spoken. Just identify the gaps, redesign your policies, synchronize between your policy and your software application, train your staff. And while training, you need to have special training, targeted training to AML staff, and then to a customer onboarding team. IT and security team need to be also in line with what is your expectation. And the AML co must also prepare a training which is suitable for your board. So the documentation you need to maintain, decision logs, risk assessments, data handling procedures. Definitely privacy and AML are now demanding equally, and we don't know what to prioritize, but definitely we can make a balanced approach between the two. This is the action plan. Review ID collection practices, update AML CTF program, implement data minimization, train staff. Phase 1, phase 2, phase 3. These are all my way of assuming within what time you have to do these phase 1, phase 2, phase 3. And phase 4 is March 2029. By this time, this is the collect less data, justify everything, embed privacy into email. Any questions? We have taken 15 minutes more. Yeah. Oh, let me see the chat. 1 second. Yeah.
The question was when the business doing these changes is faster, very fast, when other business is not ready, then that's the question that I have before as well.
Yeah. This is the same example when 10 people are speeding on the road. If one is stopped by the police and penalized, we definitely can't ask the police why you didn't penalize the 9 speeding in ahead of me. But definitely we all have to do this. I understand, Mohammed, the the whole equation is becoming either make you a big enterprise or make you quit. This is my personal. I'm not blaming anyone. Everyone is fit for Australia, but I think the small people will have to die down one day with all the pressures coming on them. Very unfortunately, because the requirement, the status of this particular business is. I have told this to many people. When people go through airport, there are immigration officers who allow people based on whether they are allowed to go out or allowed to come in. They play a very key role in allowing people to enter a country or exit a country. But we are actually de facto immigration officers when it comes to money. When money leaves Australia or comes into Australia, it cannot be repatriated without a legal enforcement action if it was criminal. So we hold the same kind of responsibility in protecting integrity of financial well-being of Australia. So me being small and doing wrong thing, definitely not acceptable. So we can't really speak for people who want to do the wrong thing and get caught someday, but let us do the right thing by following the instructions as much as possible because we have some time now. Let us talk about it. Let us do our bit for that. The second question, is that okay, Mohammed? Kind of.
Yes, that's fine.
Kind
But
of.
sometimes it will affect when you spend a lot of money and you invest a lot of things, but it will affect your
I
customer.
think it will come back. It's a learning curve until everyone do or leave the quit the industry. Customer will definitely come back. You remember one in before 10-15 years, people refused to give ID. Now they changed. It will change definitely. That is exactly what I think, and I want you to be patient on. Thank you. And the second question is the merger of part A and B. For those who listened to me when I said when you have a risk scoring module, give 80 percentage to the information which is contributed by your client at the time of onboarding, and then keep that 20 percentage score for your customer behavior, transactional pattern and behavior. So part B used to be customer identification process, and part A used to be an understanding of pillars of compliance program, which are extract of the legislation and rule comes into the gateways of the organization. But now they removed this part A and B with a good intention that the CIP is not anymore separate from the due diligence. Ongoing due diligence must happen all the time, whether or not you took all the information at the time of onboarding. So it's only in the interest of avoiding frequenting or repeatance of collection of data all the time, and also with the interest of monitoring their behavior, we are registering a customer. But registering a customer at the time of onboarding does not give you the comfort of making sure that they are the same risk, they are posing same risk. So the mixture of ongoing and the onboarding now has become one. That's why part A and B are merged. But it will still be segmented, as I said, by the pillars of compliance, the risk assessment and the risk mitigation process reference, cross reference from risk assessment document into the compliance program, and the general overall expectation document, which is compliance report submitted by to ASTRAC. All these need to be collaborated in compliance program in order to be an adequate document. It needs to be a breathing, living, which evolves on a daily basis. Is that satisfactory, Brother Loy?
Yes, thank you very much, Ron. Appreciate that.
Okay. Is there any other questions?
Ron, just quick
Thank you, brother.
question, sorry. Now, you know the flow chart of what things need to be included in that phase 1 and 2? Did you send that through?
I can
Because
send you.
is
I
that
can send-
okay? Because I just want to know, like, I know there's a lot going on, there's a lot of information, but I'm just looking at something that's going to be very simple, phase 1, what exactly needs to be done until June,
Yeah,
and then after. Does it make
that's a good approach, but at least you need to document your understanding and
Yeah.
have priorities listed and why they are lesser priority justified. And then if that is documented, I think you should be fine.
Okay. All right. So are you going to still send something through or
I
not?
will send. Yeah.
Okay. All right. Thanks.
Okay. Yeah. And there is Omar Mughal Ram. If the customer is making transaction and entered the wrong relationship with the receiver, instead of writing brother, select friend or uncle, how we check with that? See, it's to err is human. They may do mistakes during your. If what is more important is that if you have a suspicion and if you have asked them, if your customers have a behavior of not taking that, answering that question legit with seriousness, then you have a problem. You need to make them understand that this question is asked for a reason and you need to sincerely answer it. Otherwise, we will have problem with your own transaction monitoring. So if you really felt that 15 friends and you have a suspicion that in normal course people will not be sending to 15 friends, and you ask them to substantiate what is this, then at that time if they came back and said no, it was my brother or uncle, then as an excuse, you can correct and write your file note saying that the customer really had erred, and that's he did a mistake, and that's an excuse for one time. But that will not be an excuse every time. So you need to start documenting how many times you approached him, how many times he did mistake. And sometimes people confuse every you have with your customer is not tipping off. You can generally spend some efforts in educating them about the seriousness of your question's importance. Is that okay? You can rectify that. It's an editable field. Okay. So now I'm going to Basam's question. Basam is asking, is scanning to OCR open source engine, then purging images and masking data is aligned with the new OAIC privacy rules? Yes, definitely. But I want you to hold on to this until we receive more clarity, because see, a regulator may walk in, external reviewer may walk into your organization and ask for, if it is not built with complete integrity, then there may be questions about integrity of the systems built. Therefore, I want you to hold on for this for at least 10-15 days until we get more clarity as to what level of tolerance both the regulators are going to come up with. But this is a good approach, actually, in general, to answer to. But this really reminds me as to what the new requirements is seeking. Transaction monitoring rules or risk scoring rules and risk-based boundaries for people to the thresholds to people to transact, etc. You must ask for test results before you deploy those mitigation process into your system.
All right. Just to add on open source, they come with their own level of vulnerabilities.
Vulnerability. That's right.
Because they're not vendor adopted software based solutions. Just for everybody to
if you
take that
don't
into
have a
account.
formal
It's a risk.
relationship, then they may be doing wrong things. Yeah. Thank you.
Libraries can
Thanks
have
for the-
vulnerabilities. They would need a lot of attention, and that can be an extra level of headache. Thank you very much, Ram, brother.
Thank you.
Appreciate that.
Thank you, everyone.
Well done.
Thank you.